Well, I wonder if Judge Evander, who had difficulty with his video in his last, our last session, is going to be able to get it on this time.
Yeah, can you hear me, Judge Orfinger?
I can, but we can't see you, which isn't all that bad, really. Do you have a little thing that looks like a camera at the top of your screen?
No, I'm pressing start video, but nothing's happening. It has the red line through it, but
All right.
We are waiting for Mr.
okay, there we go.
Hey, look at that.
Bravo, Judge.
And you've got the right background. I can't figure out how to get the background on. You're down there at the courthouse all by yourself.
Yeah, I actually went there between this oral argument and the last one.
Yeah, I don't know why I can't get the right background, but I guess that'll be okay.
Judges, I don't see Mr. McGee yet. I'm gonna see if we can hunt him up.
Chief Judge Evander, when are we going to conference our cases?
Figure we'll do it after the third one. There's only one
Okay.
side appearing on the third one, so.
How have these remote oral arguments been working out for y'all?
We've only done one.
Oh, okay.
That was this morning at 9 o'clock.
Okay. I didn't know if they've been going on for a couple of weeks. Interesting.
I thought it went pretty well.
Yep.
Everybody joined in. We didn't have Judge Evander by video, but we had him on audio. This time we got all the judges. Hopefully we haven't lost a litigant.
Good morning, Mr. McGee. I see you're in the room. If you can turn your audio and video on. We see you, but we can't hear you yet.
There should be a button at the top. There you go.
I got it. I got it. It's coming in. All right.
Okay, good morning, Mr. McGee.
Good morning.
Thank you both. This is our second Zoom oral argument, so hopefully it will go smoothly. You should all be able to see the clock on your screen, and I'll try to help you keep time for, Mr. McGee, I don't know how much time you wish to reserve for rebuttal.
I would like to reserve about 7 minutes if I could.
Okay. And these oral arguments are being live streamed, so other people can be listening and watching. So just so you're aware of that, you each have 20 minutes, and Mr. McGee, you may start your argument.
Thank you, Your Honor, and good morning. May it please the court. I am Patrick McGee. I represent the appellant, John LEMIEUX, and we appeal entry of an order that removed Mr. LEMIEUX as personal representative of the estate of Curtis Mitchell. The lower court acted in the context of a summary judgment motion, and the court stated as follows. She said, "I recognize that removal is permissive and not mandatory." It's axiomatic that one of the standards that must be met before summary judgment relief may be considered is that the party seeking summary judgment is entitled to judgment in its favor as a matter of law. When the record before the lower court showed at best that removal of the personal representative was merely permitted, but was not required, the entitlement to removal of Mr. LEMIEUX as a matter of law was not met, and it cannot be met by definition. Removal was not met.
Mr. McGee, let me ask you a hypothetical. Let's assume you have an estate that has a value of approximately $200,000, and you have 4 beneficiaries, each entitled to receive 1/4 share. One of those 4 has been appointed personal representative. And you have an evidentiary hearing, and now at the conclusion of the evidentiary hearing, the trial judge determines that there's $175,000 unaccounted for, and the personal representative cannot give an explanation for what happened to the $175,000. Would you agree in that situation that the trial judge could remove the personal representative based on those facts at the conclusion of an evidentiary hearing and based on those findings?
At the conclusion of an evidentiary hearing for removal of a personal representative, if I believe if the court found wrongdoing and it satisfied the other elements for removal of a personal representative, and if the personal representative was the testator's choice, if the court further found endangerment of the estate, I would believe it would be within the court's discretion in weighing the evidence to decide that removal was appropriate.
With the hypothetical I just gave you, I mean, it arguably be an abuse of discretion not to deny. I mean, it would be an abuse of discretion to deny the motion to remove the personal representative if you had $200,000 estate, $175,000 totally disappeared, and no explanation by the personal representative. Would you agree that that would be an abuse of discretion not to remove him at the end of an evidentiary hearing?
I think if you're saying that there was that money in the estate and it's not there anymore, that would be evidence of wrongdoing. And yes.
Okay. So in my hypothetical, instead of an evidentiary hearing, if this was done on summary judgment, the record show there's 200,000 originally, now there's 25,000. And I know it's a different fact situation than ours, but just getting to the legal principle, and the deposition been taken of the personal representative, and he had no explanation for the missing 175,000. Could the judge grant summary judgment there? Or would the judge have to say, no, can't do it, have to wait for an evidentiary hearing?
I think that's a case that I've not seen in the case law, but applying the authorities that we have, you would think that if the only permissible outcome was for the personal representative to be removed, I think it would probably be a case of first impression. But yes, here we have a circumstance where counsel for the appellee admitted at the hearing that it's within the court's discretion to either remove or not remove the personal representative. And that's at page 3106 of the record. So
Were there any facts that were in dispute? I'm just trying to understand if there are any factual disputes here. I understand that your ultimate conclusion of whether the judge should or should not remove, you're disputing that. But as far as the underlying facts, where the money was, how it was titled, where it went, whether he could pay it back or not, those facts weren't disputed at all, were they?
I don't think you could find a material fact that was in dispute between the two sides, but the important point here is that the summary judgment evidence, those facts, some of them supported removal, some of them were in opposition to removal, some of them suggested a less drastic remedy, such as the appointment of an administrator ad litem. So you had a circumstance where the personal representative in 2012 was a joint, for example, one of the BB&T accounts, joint tenant with right of survivorship. He worked with counsel as to what should be on the accountings, whether the funds were his, whether they needed to be reported. And then 3 years later, the court determined that those BB&T accounts were such that they needed to be accounted for. But the evidence before the court, though, was that the personal representative did not have those funds, did not have the assets to repay, did not have the assets to comply. So that would suggest that at best, you appoint an administrator ad litem to confirm that if you wish, but it's not wrongdoing on behalf of the personal representative. And admittedly, by the other side, this was a circumstance where the personal representative could either be removed or not removed in the discretion of the court. And counsel also said at that same page, it requires a weighing of the evidence, which we all know you can't do in a summary judgment context.
Well, let me ask you, Mr. McGee, was there ever a request for the opportunity to present, either to claim there was disputed evidence or the opportunity to present additional evidence? Was there anything said to the judge, if we think it's improper to do summary judgment, we would have additional evidence if we had an evidentiary hearing?
Yeah, I believe you would. And
was there ever a request? Was the trial judge ever advised of that you had additional evidence if given the opportunity to present it at an evidentiary hearing? Or could the judge, based on the argument of the attorneys, assume the evidence wasn't going to change?
No, I don't think you could had it been set for an evidentiary hearing. And here's one of the reasons why. We're dealing with a 2015 petition to remove the personal representative, which was filed shortly after these rulings that the amended ruling, which after the objections to the accounting and so forth had been overruled, then they had been, a couple of them were sustained. So that was in 2015. Very shortly after that, the petition for removal was filed. And then shortly after that, a motion for summary judgment was filed in 2015. Now, we have to fast forward to 2019 when that motion was resurrected. If it hadn't been deemed abandoned, it was resurrected and brought before the court. So the facts before the court when the motion was filed, and I wouldn't think that the motion could be based upon facts other than what existed at the time it was filed, was that there was a ruling, there was an affidavit that said, I don't have the ability to pay, and then we have 4 years where the personal representative served the estate, defeated claims to set aside the will that was in place by the testator.
Mr. McGee, didn't the judge ask whether there had been any change in the evidence as far as whether the money had been put in the attorney's trust account in accordance with the prior order?
Yes, Your Honor, and it had not. But we should be permitted to present evidence concerning the and we provided an affidavit to that effect, but it wasn't detailed. That the circumstances before the court were that the money was not in there. We could provide further evidence as to what efforts had been made. There's more that we could have done. It was an unusual circumstance in that we were really defending what the facts were in 2015, not the current facts. And I think what we're dealing with in this case is the fact that we had summary judgment, which has some rigid and unforgiving tests that must be met. And all of those procedures are fundamental to due process, and disposing of a matter such as this through the shortcut of a summary judgment is at odds with a party's due process procedures that you would have at trial, and which any party would expect of the court. And when our summary judgment process is broken, when the tests are not met, we cannot disregard the process, turn a blind eye because we might feel that the end result is somewhat or to some degree acceptable. So we cannot give only lip service to our summary judgment requirements. We all know what they are.
But getting back to Judge Orfinger's question about material undisputed facts, I mean, we have the fact that the judge determined, it was not appealed, that the $125,000 in those bank accounts belonged to the decedent. I believe your client's testimony at that prior hearing had been that none of the money had been put in by your client. So you had that the judge had determined there's no right of survivorship. So that $125,000 belonged to the estate. There's no subsequent challenge to that. That the judge ordered the $125,000 to be put back in essence by putting it in the attorney's trust account. That is undisputed, that had not been done. And it's undisputed there's an affidavit saying, I don't have the funds to do that. What other facts are there that were suggested to the trial court as to why the trial court, based on those facts, shouldn't remove, the PR? What concerns me is remand in this case for an evidentiary hearing and the exact same evidence comes out.
Well,
I understand your argument about the procedure, but I didn't see anything below or really in your brief as to how things would be different at an evidentiary hearing.
Well, what would be different is that my client could be in front of a judge, provide his testimony, cross-examine witnesses or evidence that the other side wishes to present in an evidentiary hearing. He could provide further testimony. He could pull in the witnesses, the attorneys. Of course, we didn't have the affidavits from attorneys in this case, but he could confront his witnesses. And in this instance, this is exactly what I was saying, that if we are going to have due process rights determined by summary judgment, knowing that the trial court weighed the evidence, knowing that it's admitted by the other side that weighing the evidence is required, knowing that that's impermissible on a summary judgment procedure, knowing that the results were discretionary with the judge, she could have either removed or not removed the personal representative, then what's being suggested is that let's just go ahead and let it happen because we're comfortable enough with the outcome.
The estate was less. The estate was less than 800,000, less than 600,000, right? Less than 500,000.
I wish I could recall that off the top of my head, but
yeah, I think in the record it's, based on what your personal representatives thought as 3% of the total value of the estate, suggested an estate of about $400,000. So if the 125,000 would be more than your client's share, and if based on the facts, the undisputed facts presented to the judge, would it have been an abuse of discretion to have not removed the personal representative?
I don't think so at all. And let me make 2 points. I don't think you remove a personal representative because of the inability to pay when there's no showing of wrongful conduct and no endangerment of the estate. And secondly, since 2015, there have been hundreds and hundreds of hours put in by this personal representative for which he is entitled to compensation, in connection with all the trial proceedings and other matters that have been prosecuted. There was an extensive trial in this case where Mr. Kangus's other client, I believe it is, sought to have the will and a related trust set aside on the grounds that there was no testamentary capacity and that there was undue influence by Mr. LEMIEUX. They lost. He appealed. There's still going to be an attorney's fee award in that case, and there's going to be an award for Mr. LEMIEUX's compensation. There will be, according to ruling from a separate judge since 2015, an allocation of those attorney's fees against the share of one of the beneficiaries. So when all the funds come out, I'm not so sure that even if you do the math and take away the 125 and any other numbers from there, that when Mr. LEMIEUX is compensated and those numbers shake out, that he doesn't recover from the estate. So,
Counsel, given the undisputed facts below, and I understand your argument about the trial judge needed to weigh those facts, but what other evidence could there possibly have been? I mean, just give me it's a theoretical question. What evidence could have been presented at an evidentiary hearing that would have excused the amount of money that's missing here?
We're not. Well, two parts to my answer. We're not talking about excusing it. What we're talking about are the consequences of Mr. LEMIEUX after 3 years not having the money to pay back into the estate. So that's a given there. As far as the additional facts, it would be that in the fall of 2018, let me have my figures right. There was a pending motion for fees and costs. That's since been heard by Judge Galuzzo, and an order's been entered, and there will be an evidentiary hearing on that, and also an evidentiary hearing on the compensation to Mr. LEMIEUX. So that's evidence all in itself that could change the calculations drastically. There's no damage to the estate, no harm to the estate, and no financial harm to the estate. We should be entitled to.
Counsel, the judge didn't enter a judgment against your client. I mean, if he's entitled to fees, I guess he's entitled to fees. And if the judge ultimately concludes, as they did, that he took money that he wasn't entitled to, he'll get a credit against that amount for his fees, I suppose. But he's not been held in contempt. I'm not sure what additional facts could be heard. So he's entitled to fees. So he might be entitled to a credit against whatever the judge ultimately determines he took from those BB&T accounts that he wasn't entitled to. I'm not sure where I see the dispute of material fact that precludes a summary judgment.
Well, what you have is facts in this case that that were offered in opposition to the removal. The judge recognized that it was discretionary under the facts of this case. It wasn't mandatory. Mr. Kangas conceded that on the facts that were before the court could either remove or not remove, just on the facts that were before the court, and that the court had to weigh the evidence to do so. So what we should be entitled to do is to play out the attorney's fees, have an evidentiary hearing as to what the numbers are going to be, address whether there's harm to the estate, and consider whether removal under those facts is appropriate when it's the testator's choice, when there's no wrongdoing by the personal representative.
Mr. McGee, you're down about 2 minutes, so just go ahead.
Thank you, Judge. I mean, the issue here is, as I say, whether we are going to turn a blind eye to a summary judgment procedure that weighed the evidence and did not satisfy the tests of summary judgment. And if we're going to do that and be somewhat satisfied with the result, then I think that's wrong. I don't think that's what we should be doing in the court system. We have due process procedures, and shortcuts like this are not warranted. Thank you.
Thank you. Mr. Kangas?
Good morning, Your Honor. May it please the court. Michael Kangas on behalf of Robert Mitchell Jr. as the personal representative of the state of Robert Mitchell. We're here today to ask that this court affirm the lower court summary judgment, removing the appellant as personal representative of the estate of Curtis Mitchell. The lower court correctly granted summary judgment because there was no justiciable issue of fact related to the claims under 733.5043 and 4, which was the disobeyance of an order of the court and the disobeyance of the order to produce assets of the estate when so required. Further, the court made previous findings that the appellant solely owned a company and that he knew of a debt, a loan that he had borrowed from the estate and did not acknowledge that, or from the decedent, and did not acknowledge that on his accountings. And the court had already ruled that that was an asset of the estate. There was a prior full trial in October of 2014 where Mr. LEMIEUX had the ability and the opportunity to present evidence, to cross-examine witnesses. And even at the summary judgment hearing through counsel, he acknowledged that those findings are no longer disputable because they're already in a final order, and the appeal of that was dismissed for lack of jurisdiction because no timely appeal was taken. As the Florida Supreme Court held in the Landers case, a movement for summary judgment has the initial burden of demonstrating the non-existence of any genuine issue of material fact. But once he tenders competent evidence to support his motion, the opposing party must come forward with counter evidence sufficient to reveal a genuine issue. It is not enough for the opposing party merely to assert that an issue does exist. And that's what's happening here today. There was no summary judgment evidence put on about these calculations of set-offs. And I don't even agree that if there was a set-off that the estate could have made whole, that is a defense, a valid defense to removal. The idea is, was there a defalcation? Did he forget to account for an asset? Did he not return assets that he was directed to return? Did he not acknowledge another asset of the estate that personally benefited his company, a $70,000 loan? And for all of those reasons, and the facts were completely undisputed, I completely agree, I think, with Chief Judge Evander and Judge Orfinger's questions that implied that there's no dispute of fact. There was no reason to go to trial on any of these issues.
And what's your response to Mr. McGee's argument that if the trial judge had discretion to deny the motion, then summary judgment is inherently improper procedure?
Well, although there was discussion of that at the hearing, I think I would refer this court to the Sins case, or actually the Bell case, which is cited to either by Guinier or Sins. They're both referred to in our answer brief. And in that case, it was held that upon finding the personal representative, upon finding the PR has an adverse interest due to a claim of certificates of deposits belonging to an estate, removal was required. So I think under the case law espoused in Bell, the court got it right because it was required. At that point, it was required to be removed. The Guinier case reversed a trial court order and remanded for removal of a PR when the conflict arose when the personal representative asserted a personal interest in an estate asset. And here we've got 3 different assets where the personal representative is doing the same thing, and there's already been findings after a hearing that those assets do not belong to him. And that being a $70,000 loan to one of his companies and the $125,000 making up the BB&T accounts that he did not return. So although generally it's a discretionary decision for the judge, I think the case law in Florida supports a requirement, especially the Bell case, 573 Southern 2nd 57. I just want to touch on a couple things that were argued by the other side. There's advice to counsel or reliance on counsel was raised, but if this court were to look at the response to the petition for removal, that was never raised as a defense. And I think it's the accurate metal finishing case that's cited in footnote 5 of my brief is you can't raise affirmative defenses for the first time on appeal. There's an argument it could have been raised during the prior hearing, but that didn't happen. The other issue about this whole set-off thing, there was no summary judgment. I already stated that. There's no summary judgment evidence to support that. So based on the arguments made today, I would ask that this court affirm, and unless the court has any further questions for me, I'd yield the rest of my time.
All right, thank you. Mr. McGee?
Thank you. I'll go very, very quickly. The Bell case is quite distinguishable on its facts, and the Bell case, neither the Bell case nor any other case has called for removal of a personal representative in a summary judgment procedure. Mr. Kangas could have asked for a hearing, an evidentiary hearing. He didn't. He just obtained a hearing time. It's improper for that to occur the way it did. There's a distinction between conflicting inferences in the evidence, conflicting evidence, reaching a different conclusion, and disputed evidence. The evidence that was presented leads to different conclusions. Summary judgment is inappropriate in that case. The rule requires 5.10C that summary judgment shall be rendered if there is no genuine issue of material fact and the moving party is entitled to judgment as a matter of law. We all know that on the facts of this case, it is conceded by both the trial judge and Mr. Kangas that either result, removal or non-removal, was permissible on these facts. Summary judgment was wrong. It should be reversed. It should be remanded for the proper procedures. Due process requires such. Thank you.
All right, thank you both. And that will conclude this particular oral argument session. And we'll be back at 11 o'clock for the third oral argument of the morning.
Thank you, Your Honors. You have a great day, everybody.
Thank you.
Thank you.